Hi, I'm Anne Marie Sunday with Legacy Property Management, and if you're a landlord in Colorado, this is big. We have just seen four new laws get passed affecting property owners and managers that are effective immediately in the state of Colorado. So let's get started. I just want to do a brief overview of the four. The first is application fees. And by the way, this applies to all landlords across the board, not just property managers. If you own one condo or one single family home and you rent that out, it doesn't matter the size of your company or the size of your portfolio, these laws apply to you. This new law limits the amount that can be charged for an application fee. It also requires disclosure of what you're going to use those fees for, and it requires receipts for the applications. So you say, okay, well, that seems fair. Sure, that seems reasonable. Good. It also requires specific action to be taken when an application is denied. So you can't just say, sorry, you're denied. You have to follow the requirements to deny those applicants. And it requires you to refund any of that application fee that's unused back to the applicant. Another interesting area that this law applies is it limits the information you can consider when processing an application. Now, this is really big because you may not take into account when considering the applicant now, you can't judge beyond 7 years for rental and credit history. That can't be part of the consideration for this applicant. And for criminal, you can't go beyond 5 years with certain exceptions that's stated in the law. And we won't get into detail, but this has a huge impact on how we are basing our decisions on applicants applying for properties. And I just wanted to make sure you are in compliance. The second law relates to bed bugs. Specifically, a few items that might be important to you. Say if you're a property manager or a landlord and you're notified that a tenant thinks they might have bed bugs. The clock starts ticking the moment you are notified, and you are required now to have 96 hours to find a qualified inspector to determine if this is a bed bug issue. And it must now be a qualified inspector. You can't just go to Home Depot, buy the bed bug getting rid of thing. You now have to have an inspector. They must report their findings to you and the tenant. And then the treatment to eradicate is at the landlord's expense. It doesn't matter where these bed bugs came from. It will be at the landlord's expense. So, does these laws negatively impact the landlords? We don't think so. These seem so far to be pretty fair. Let's talk about law number 3. This is the warranty of habitability. Now, the Colorado already has a law of habitability, but this law extends the current one that's in place, and it greatly expands the tenant's rights within the warranty of habitability. So warranty of habitability really means that we as landlords are required to provide a habitable property to a tenant. Like you have to have running water, or you have to have heat. You have to do things that you would, normally think of. This new rule, though, expands what those requirements are and greatly reduces the leverage a property manager or a landlord has in fixing these items that might be questionable and how quickly you get them fixed. For example, you are now required to give specific response from landlords in a specific time frame. The clock starts ticking once a notification comes in from the tenant, and if they suspect something is broken or needs repair and it's on the habitability list or issue. This bill now allows tenants to legally withhold their rent or not pay it if it's a habitability issue. This rule is pretty complex, so I'm not going to get into the specific details, but it does allow tenants to withhold their rent. It also greatly expands the landlord's potential liability for retaliation, and getting back in specific ways to their tenant. So let's go through maybe an example. When a tenant gives a warranty of habitability notice, for example, he says, hey, I think I have mold. This is going to fall under the umbrella of warranty of habitability. The new law now requires you must respond within 24 hours of getting that notice. So this could be really tricky. What if you get that notice at 12 midnight on a Friday night? Doesn't matter. You have 24 hours to respond, and the response must contain indicating the landlord's intent for remedying the condition, providing an estimate of when the remediation will begin. This is tough because we don't even know the contractor's schedule yet. So within 24 hours, we have to acknowledge, respond, provide an estimate of when work will begin, and then we must provide an estimate of when the remediation will be complete. We have no idea what's going on. Tenant calls, says he has mold. Well, is it cleaning of the wall or remediation of the entire house? It's pretty crazy, but like it or not, this is what we're required to do. There are, like I mentioned, some intricacies to this law, so we won't get into the details of that at this moment. The last law is the 10-day cure. And you may have heard 3-day notice. Tenant doesn't pay rent, you post what is called a 3-day demand for possession or compliance, stating the tenant, you have 3 days to pay your rent, or we can potentially begin the filing for an eviction process. Well, no longer is 3-day available. That's gone. It's now changed to a 10-day notice. And there are some caveats in this bill as well. With the example is if you're an owner of a single family home and you don't own too many properties, then you don't need to do a 10-day. You could do a 5-day. But if it's a condo or a townhome, then you're required to do a 10-day notice. And if you own more than a certain number, obviously you are at a 10-day as well. We don't know that number, so that's still up in the air and very vague, but I wanted you to understand 3-day notice is gone. It's all at a 10-day or potentially a 5-day with caveat. So what does this apply to? Well, it applies to rent demand. So if the tenant hasn't paid rent, this is applicable. It applies to demand for compliance on non-monetary violations. Perhaps it's an HOA violation or violating a term or condition in your lease you want to evict for, or repeated notice to quit for repeated violations. All of this is applicable. Here's what's interesting. Our attorneys are stating with this new 10-day requirement, the absolute soonest you can get a court date for non-payment of rent would be the 22nd of the month. So rent is due on the 1st. You get out there, you post your notice. The absolute soonest you're going to be in court is 22nd. Now, so what this does is greatly expands the eviction process. So before 30 days would be tight, but we could probably do it. But for sure, usually an eviction could happen within 45 days. Now we're looking more like 60. And in our opinion, this rule doesn't allow us to work well or easier with tenants to try to find a solution, which we really want to do. And we're seeing that it could, where our eviction rates in our company have been less than 1% per year. We could see that this could go higher because tenants can't catch up and they're falling behind with late payments or partial payments. Now, if you're a client of Legacy Property Management, don't worry. We have had our attorneys revising contracts to incorporate the verbiage that's required for these new laws, and we are ensuring that we are operating under the confines of these laws and all the laws with regard to tenants and real estate laws. If you're not a client of ours, then please talk to your PM company to ensure they are doing these things to protect you. It doesn't really matter if you are a PM or you are managing on your own. You need to ensure you are adhering to these new laws. And it's definitely shaking up some things in our industry. Thanks.